Hello, welcome to How the Right to Privacy Devolved into the Right to Terminate a Pregnancy. This course is designed for Christian educators who are interested in learning more about abortion law or where we currently stand. The year I'm recording this is 2023. Last year, the Dobbs decision came out from the Supreme Court, ultimately holding that Roe v. Wade and KCV Planned Parenthood need to be overruled, and ultimately decided that the states need to decide whether life is worth protecting and what sort of state interests are involved in allowing a woman to have the right to obtain an abortion. So this course provides a pretty general overview of the historical context from really how we got to Roe v. Wade, and then the post-Roe world that we are living in after the Dobbs decision. This, at the moment, is just a single lecture. So as you'll see, it gets a pretty broad overview, but I do pray and hope that this helps inform the current and ongoing debates that are had to help really quell a lot of the misinformation that I think exists when it comes to abortion law. So without further ado, my name is Cole Watson. I'm an instructor at Rise and Build Academy, where we provide online education for the next generation of kingdom builders. So, to begin, we'll start with a landmark case that has profound impact on individual liberties in the United States. Griswold v. Connecticut is a case that established the right to privacy as a fundamental constitutional right. Before we dive into the details of the case, let's set the stage by examining the historical context that led to Griswold v. Connecticut. It's set in the early 1960s when access to contraceptives, particularly birth control for married couples, was restricted by state law. So, in this example, Connecticut basically passed a law that said no contraceptives with certain exceptions, but the general policy reason was to prevent or otherwise dissuade extramarital affairs. State apparently had an interest, a reason why they wanted a law in place that would otherwise dissuade married couples from leaving the confines of their own marriage to seek extramarital affairs, or so they say. There could be a whole host of implications there. So the Connecticut law had specifically prohibited the use of any contraception, even for married couples. So it was under these circumstances that Estelle Griswold, the then executive director of Planned Parenthood, which we will hear plenty about in this lecture, the Planned Parenthood League of Connecticut and Dr. C. Lee Buxton challenged the constitutionality of this law. So, as a quick pause, right? We have the Constitution in place. It provides an incredible breadth of rights and systems and structure that our federal government, the United States federal government, is based on, right? We wouldn't have the system we have in place without the Constitution. So when laws are challenged from a constitutional basis, usually what the court has to figure out is if there is any sort of touchstone that they can tie back into the Constitution to ultimately determine whether a given issue is a matter of constitutionality. So the issue here for the Griswold case in particular was whether the Constitution protected the right of married couples to use contraceptives, and more broadly, whether there exists a right to privacy that could be inferred from the various provisions of the Constitution. Now, without getting into a lot of the nitty gritty of the Constitution, let me just say there's no mention of privacy. Okay, there's no mention of contraceptives. There's no mention of marital rights in the Constitution. That does not exist. And so I hope, and maybe it already is, the question that should be lingering in your mind right now is: wait a second. How are we going to go from the Constitution to asking this question of whether a law that forbids the use of contraceptives unconstitutionally intrudes upon the right of marital privacy? So the court analyzes previous cases that address the First Amendment. The First Amendment is here: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievances. There's a lot packed in there. For our purposes, though, we're really looking at the freedoms that the First Amendment provides. And if you can read that, I encourage you to spend some time, maybe pause this lecture now and pinpoint where you're going to see privacy in there, or any kind of marital rights, or the right to use contraceptives in marriage. Short answer, it's not there. So even though the First Amendment never mentions the right to privacy, the court reasoned that the First Amendment has a penumbra, 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 where the privacy is protected from governmental intrusion. Penumbra means the combination of almost and shadow in Latin. From this conclusion about the penumbras within the First Amendment, the court further concluded that there are certain zones of privacy that includes the right to marital privacy. This is a stretch, to say the best, okay? From the reading of the First Amendment, in addition to some other cases that the court looked at, they basically concluded that there is a right to privacy, that there's a certain concept where we as individuals have a right to not have other people look in on what we're doing. The government in particular cannot look into what we're doing in our homes, for example. There's a right to association, and there's sort of an implicit right to be a part of that association and have the affiliation or the association with that group, with that political party, whatever it may be, broadcasted. So there's a right to have the privacy within association. And that's how the court basically makes their jump into saying, you know what, we're going to read this rule. It sort of casts a shadow out here that there is a right to privacy here. Okay, let's analyze this a little bit further. So in the majority opinion, the court looked to various constitutional provisions, including the First, Third, Fourth, Fifth, Ninth, and 14th Amendments, to discern the existence of a broader right to privacy. Again, the concept of privacy is not in the Constitution. The court is basically having to aggregate and look at these different amendments to the Constitution to sort of pull out a concept of privacy, a shadow, a penumbra. Although the Constitution does not explicitly mention the right to privacy, the court found that it was implicit in the penumbras or shadows cast by these specific amendments. So, in this landmark decision, the Supreme Court held that the Connecticut law violated the right to marital privacy. The court concluded that the Constitution safeguards a fundamental right to privacy that protects the intimate decisions made by married couples, including the right to use contraceptives. The closing paragraph of the majority opinion is worth reading. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. The court just called marriage sacred. Pinpoint that for a later time. The Supreme Court of the United States of America called marriage sacred. It is also an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble as a purpose as any involved in our prior decisions. So high regard, right? A very high regard for marriage. And by virtue of having that high regard for marriage, we seem to make a jump that says there's certain rights that are included in associating together as a husband and wife, as a married couple, because that is by all means what this court has in mind when they say marriage, such that the right to privacy, whether to use contraceptives within marriage, is worth safeguarding by virtue of the Constitution. So the Constitution all of a sudden provides for the right to privacy This Connecticut law that forbids the use of contraceptives within marriage is now considered unconstitutional. So, although the right to marital privacy is not found in the Constitution, it is heralded as a right older than the Constitution and political parties. The significance of Griswold v. Connecticut cannot be overstated. It not only struck down a restrictive state law, but also established the right to privacy as a fundamental constitutional right. This decision laid the foundation for subsequent cases such as Roe v. Wade, which recognized a woman's right to choose to obtain an abortion, which we'll discuss here in a moment. The groundwork here, though, is just critically important. We're going to go from the right to privacy, and we're going to somehow see that right devolve into a right to obtain an abortion. So the concept that the right to privacy is somehow found in the Constitution is just worth digging into and diving into a little bit deeper. So Griswold v. Connecticut marked a turning point in American constitutional law, which shaped the landscape of individual liberties. By recognizing the right to privacy, the court protected the intimate decisions made by married couples, really, upheld their decision-making capabilities within the confines of privacy of their own home. This case serves as a reminder as well that the court can construe the Constitution as a living document. If you've heard that term before, it's the concept that it's not just the words on the page. Because if it were, plain as day, read it. There's no mention of privacy. There's no mention of marriage. There's no mention of contraceptives. Boom, we're done, guys. We can go home. We call it early. We didn't have to do all this hoop jumping and hopscotching around. But if you hold to the legal theory that the Constitution is a living document, that means it's going to change with what's required of the current times. Very important concept because it's highly debated. Should we stick to the text of the Constitution and stick to the text only? Or should we be a little bit more lax with how we're going to interpret the words and where we can find these shadows and penumbras within the confines of the words, reading between the lines, so to speak? So if you hold to the belief of the concept of legal theory that the Constitution is a living document, you basically believe that the Constitution is capable of adapting to the evolving needs and expectations of society. It's a tool or weapon that can be used in a number of ways depending on who's in office. Whether this approach of interpreting the Constitution is good, right, or just is a matter of intense debate, as I'm sure you could imagine or have taken part in. For now, it's worth noting that the court called itself out, an eerie foreshadow of future decisions. The court says in the Griswold case, we do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or social conditions. This law, however, operates directly on an intimate relation of husband and wife and their physician's role in one aspect of that relation. Nevertheless, the court still asserted the right to privacy was constitutionally protected. This ultimately pays the foundation for Roe v. Wade. If you are a part of the Foundations of Law course that is being offered in the fall of 2013, as well as future semesters as well, we've touched on the concept of stare decisis, to stand by things decided. That is a fundamental concept in law. It's how we have certain accountability, certain predictability, regulated, really, law and orders. We know what to expect because we're going to look to precedent. We're going to look to what's happened before to determine what should happen, or the result that should happen moving forward. So moving on to Roe v. Wade. This is a case that built upon the foundation laid by Griswold v. Connecticut and solidified the right to privacy as it pertains to a woman's decision to have an abortion. So, the historical context first. This case is set in the early 1970s. So we're out of the 60s, and I don't need to get too far into the historical analysis, but again, context, we're coming out of the 60s, around the early part of the 70s, depending how you want to slice and dice United States history, whether you're looking at the civil rights movement, the Vietnam War, the first couple waves of feminism, anything you want to look at here, this is where this case is situated. So we'll take all those strands of history that are coming out of the 60s, that were woven and started in the 60s, and now are exploding across the landscape of the United States. And we're in prime fertile ground for a monumental decision with Roe v. Wade. So in the early 1970s, many states had restricted abortion. They had restrictive abortion laws that actually criminalized the procedure with very few exceptions. It was in this environment, again, the 60s, right? All the strands of history going on, as well as the criminal nature. Okay. We'll touch on that here in a second too, but it's hard to imagine, but this at one point was a crime. If you live in states like Texas, where I am, it's now a crime on sort of the opposite end of the spectrum. Doctors would be considered criminal if they performed an abortion. If you got someone, if you helped aid a woman in obtaining an abortion, you could also be a criminal. But for now, let's just situate ourselves in this historical context. Feminism, okay, Vietnam War, civil rights, and abortion's a crime in most states. Not all, most states. So it's in this environment that the plaintiff Jane Roe, just a pseudonym, you can look up more of that story later too, challenged the constitutionality of the Texas abortion law. So the issue at stake, right? We touched about it in the Griswold case, the constitutional aspect when there is seemingly a fundamental right that is being challenged or is being taken away. That is usually the route that's taken is, wait a second, guys, this isn't constitutional. Now, again, the Constitution does not mention abortion at all. Doesn't mention pregnancy, doesn't mention contraceptives, it doesn't mention marriage. It just doesn't touch on it. That's not really what the founders had in mind when they're putting together the Constitution. Now, they did anticipate that changes would be necessary, but parameters and mechanisms were put in place to ensure that this took place. However, the issue we're at now with Roe v. Wade is whether a woman has a constitutional right to obtain an abortion. So let's revisit Griswold real quick. As we just discussed, the Griswold court recognized a right to privacy that was not explicitly mentioned in the Constitution. The court found that this right was implicit in the penumbras or shadows cast by various constitutional amendments. Griswold laid the groundwork for recognizing a fundamental right to privacy that extended beyond the contraceptives within marriage and had broader implications for personal autonomy. The central issue in Roe v. Wade was whether a woman has a constitutional right to obtain an abortion. The case asked the court to determine the constitutionality of the Texas abortion law, which basically criminalized the abortion procedure, except to save the life of the mother, in some various other exceptions therein. The rule, again, if you're following along the framework here that we discussed in the Foundations of Law course, we're going to go from the issue to the rule, right? That objective standard. What's that tertium quid? What are we going to actually bind ourselves to resolve a dispute or a dilemma? And then we're going to do the analysis and the conclusion. That's generally how we're going to read cases. That's how we're going to present any kind of legal dispute as well. As a practicing attorney, even when I'm talking with clients, that's the same framework I use. In these sort of cases, though, it's hard to pinpoint the rule exactly. So right now, there's a concept of there's a right to obtain an abortion. That's on the one end, the Jane Roe saying, I have a right to obtain an abortion. And on the other end, there is a law in place that says, nope, it's a crime, actually. So not only is it not a right, a positive, it's a negative. It's a crime to obtain. And those two things clash. And so the court has to look at the tertium quid, the third thing, the Constitution in this regard. So the Constitution here, and going to look at it and say, you know what, where are we going to find whether a woman has a right to obtain an abortion? Okay, so this law, Texas law, essentially banned abortions except when the mother's life was at risk. Not really an issue in this case. It wasn't like She needed to have an abortion to save her life. It was what's called a class of plaintiffs that were basically women that were pregnant. That's all it really came down to. So the court has to basically reconcile this concept of women are saying they have a right to obtain an abortion, a constitutional right, a foundational right that is heavily guarded, versus a law in place that the people of Texas have elected their representatives to pass that says, actually, no, it's a crime to abort the pregnancy. So the court's decision in Roe was primarily concerned with the constitutionality of the Texas law, right? State law can't violate the Constitution. That's another foundational legal premise. It's the right ordering of things. So the court's ruling in this case had to have far-reaching implications. So in other words, it wasn't just this particular case. I think that's maybe or overstating the obvious, but it wasn't like it only came down to J. Roe. Or yes, it came back to the larger implications for the more or less universal right to obtain an abortion versus any other states passing laws that would otherwise restrict or criminalize abortion. The rule itself, though, we're back to the First Amendment. We're back to kind of piecemealing the Constitution, the amendments together to figure out, well, is there any kind of shadow here? Is there any kind of penumbra that we can point to resolve this? Probably read ahead, but no, there's not. So in the majority opinion, written by a man named Harry Blackmun, which we'll touch on him at the end too. Justice Harry Blackmun wrote this majority opinion. He reaffirmed the right to privacy recognized in Griswold and extended it to include a woman's decision to have an abortion. The court held that the constitutional right to privacy is broad enough to encompass a woman's right to make decisions about her own body, including the decision to have an abortion. So we went from the right to privacy, which has nothing to grab onto in the Constitution except for these shadows that are weirdly cast. And now the court is extending that fictitious right into the right to obtain an abortion. It's the woman's body. It's the woman's choice. We've heard that rhetoric now for a very long time, several decades. However, the court also recognized that this right is not absolute. Wow. It must be balanced against the state's interest in protecting maternal health and what they termed potential life. Yes, the child inside the woman, believe it or not, actually got discussed. It was discussed insofar as it was a potential life. So in particular, the Supreme Court established a framework for evaluating the constitutionality of abortion laws based on the stages of pregnancy. No precedent here. No precedent whatsoever. Maybe there was a doctor somewhere that wrote a brief or had some comments about there's 3 trimesters and trimester 1, 2, and 3 mean different things along the pregnancy. It sounds like a very nice way to look at a pregnancy, but beside the point. So this framework that Roe just kind of made up, basically, is commonly referred to as a trimester framework, which divided a woman's pregnancy into 3 distinct trimesters and assigned different levels of state interest, the state interest that they would have in the potential life, right? The state interest they would have in the child. So never mind what the child thinks, right? We're not going to think about that human life. We're not going to think about that imago Dei element of this situation. We're only thinking about, the woman and her body, and she gets to have the right to choose to abort her child. Potential life. And then the state probably has an interest in populating their jurisdiction and, having other little taxpayers that grow up to become tax-paying, law-abiding citizens or whatever. So they look at and they say, okay, so a woman's roughly pregnant for 3 months. Threes, that kind of makes sense. Not divided by 3 months, trimester. Okay, so first, second, third trimester, where does this spectrum between a woman's right to obtain an abortion, which how they found that out, okay, right to privacy, blah, 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 compared to a state's interest in that quote unquote potential life. So in the first trimester of the pregnancy, the court held that the decision to have an abortion should be left to the woman and her healthcare provider. The state's interest in regulating abortion during this period was deemed minimal, and any restrictions on access to abortion were subject to strict scrutiny, meaning they had to be narrowly tailored to serve a compelling state interest. The state had to have a really, really good reason why they would say, we're actually going to protect that child's life. that potential life for one reason or another. Otherwise, lady and your doctor, not the husband, not the father, lady and your doctor, y'all get to decide. Second trimester. So we're kind of moving in that spectrum, right? Start of the pregnancy, from conception to birth. We're in the trimester framework. So in the second trimester, the court recognized that the state had a greater interest in protecting the health of the pregnant woman. Thus, regulations can be imposed on abortion procedures, but they must not impose an undue burden on a woman's right to choose. The court defined an undue burden as the regulation that had the purpose or effect of placing a substantial obstacle in the path of a woman seeking abortion. Trying to limit my commentary here. Just read from my script. Third trimester. During the third trimester, the court held that the state's interest in protecting potential life becomes compelling. They have better reason to say, you know what, kids made it this far, we should probably let the kid be born and not kill the kid while in utero. The court allowed the state to prohibit abortions except when necessary to protect the life or health of the pregnant woman. However, regulations must include exceptions to preserve the life or health of the mother. It's important to note that the trimester framework was designed to balance a woman's right to choose with the state's interest in protecting the other lives involved, both the mother and the child, or the potential life, as the Supreme Court called a child in utero. However, as we'll see in a moment, subsequent Supreme Court decisions modified and replaced the trimester framework with simply the undue burden. So are you getting in the way of the lady? Is she trying to go get an abortion and the state's getting in the way of that? Ain't going to fly. We're going to say it's undue burden, unconstitutional, and we'll strike down that law. So that is our next case, the KCV Planned Parenthood case. For now, let me just touch a little bit more on the Roe v. Wade decision, just because of how monumental it is. I am an attorney, to be fair, and I like reading legal cases and studying the implications. I truly do not believe I can overstate the magnitude that this decision had and continues to have for a variety of reasons, but not least of which is the number of lives that one man, a panel of men, could have on entire generations, the entire society of the United States of America. It baffles my mind, I guess, at times to think about the magnitude that, we're talking about words on a page here. I wish I could pull up the opinion for you right now. It's pretty hefty. But it's just important to recognize that it's not just words on a page that are disseminated and promulgated. It's lives. Okay, it's lives at stake here. So the decision to legalize abortion nationwide and establish a framework for evaluating the constitutional abortion regulations, just like I said, cannot be overstated. Roe v. Wade solidified the right to privacy as it pertains to reproductive choices and fundamentally changed the landscape of reproductive rights, quote unquote rights, from crime to right, in the United States. Roe v. Wade also sparked significant debates and activism with both proponents and opponents of abortion rights engaging in ongoing legal, political, and social battles. Since its ruling in 1973, Roe v. Wade has faced ongoing challenges and controversies. As we'll discuss here in a moment, Planned Parenthood v. Casey also redefined that legal framework that was used to determine whether a given law is quote unquote constitutional, that undue burden framework. So the Supreme Court used various cases in support of the broad proposition that a woman's interest in making the fundamental personal decision whether or not to bear an unwanted child, so now here's a child, an unwanted one, is within the scope of her personal rights protected by the 9th and 14th Amendments. Again, encourage you to look up the Constitution, the amendments to the Constitution, and look at the 9th and 14th and point out where that right came from. But this right was not absolute, as Justice Blackmun continued, because the pregnant woman cannot be isolated in her privacy. At some unspecified point in the pregnancy, another being becomes involved, and the privacy of the woman that the woman possessed has become dual rather than sole. Two, not just one. The woman's personal right, therefore, must be balanced against the state's interest. And the state's interest is just a shortcut to say the child's life. At some point, the state cares enough about the child to intercede, step in, and say, you know what, lady, your right to abort this child is no longer, and the state's going to step in and say, we're going to protect this life. Where that point in time is, unspecified. Okay, the judges did the best they could to say three trimesters here. One, okay, that's going to be on the woman's side of things. Three, it's going to be on the state side of things. Two, don't cause an undue burden. Y'all figure it out. But it's an unspecified point in time of when it goes from dual to, or it goes from sole to dual, right? Dual rather than sole, two rather than one. In preparing for this lecture, I found this book, Becoming Justice Blackman. If you can see it there, it kind of works. By Linda Greenhouse. She tells a very interesting story in here, too, about how Justice Blackman had a family dinner at one point before he'd written this decision. He'd been assigned the case by the Chief Justice. It was his responsibility to write the majority opinion. And his youngest daughter tells a story. During a family dinner, Dad brought up the issue, the issue, right? The abortion issue. What are your views on abortion? He asked the 4 women at his table, his wife and 3 daughters. Mom's answer was slightly to the right of center. She promoted choice, but with some restrictions. Sally's reply, the other daughter, or the lady's telling the story, her sister, Sally's reply was carefully thought out in middle of the road, the route she has taken all her life. Lucky girl. Nancy, a Radcliffe and Harvard graduate, sounded off on an intellectually leftish opinion. I had not yet emerged from my hippie phase and spouted out a far to the left, shake the old man up response. Dad put down his fork mid-bite, pushed down his chair, and said, I think I'll go lay down now. I'm getting a headache. I don't know why necessarily that story sticks with my mind, but again, going back to the point I made earlier at the top of this section, these are not just words on the page. And so to have that sort of abdication in my mind of this man saying, you know what, ladies, what do y'all think about this? I've never been pregnant. I never will be pregnant. What do y'all think about this? It worries me. It worries me that men in this society are not taking their headship responsibilities seriously and not recognizing that the role that God has given us to be stewards and shepherds of our families, to lead out our churches and our communities, is not taken very seriously. There are serious ramifications from every single job that we have and every single job that we do. No, I will never be a Supreme Court justice, but the just man justices, as the poem tells us. So with Justice Blackman here in particular, he had this other line as well. It is not for us of the judiciary, especially at this point in the development of man's knowledge, to speculate or to specify when life begins. The court needed to do no more, he said, than to note that the state's interest grows stronger as the woman approaches term, and eventually the state's interest becomes compelling. Or, as he said, when another being becomes involved and the privacy the woman possessed has become dual rather than sole. Life matters. Life matters. We are created in the image of God. Life matters, and it's worth defending, and it's worth protecting, and it's worth fighting for. Men that abdicate their responsibility to protect life are just as good as Adam, abdicating his responsibility in the garden when the serpent comes and tempts Eve. Moving on to Planned Parenthood of Southeastern Pennsylvania v. Casey. This is a 1992 case and largely echoes the Roe v. Wade decision. This case built upon the foundations established by Griswold v. Connecticut and Roe v. Wade, while also introducing a new legal standard. As we discussed, Roe v. Wade established the constitutional right to an abortion, recognizing that a woman's decision to terminate her pregnancy falls within the right to privacy. However, the ruling in Roe v. Wade sparked ongoing debates and legal challenges, leading to subsequent cases that sought to shape the boundaries of this right. One such case was Planned Parenthood v. Casey. The central issue in Planned Parenthood v. Casey was whether a set of Pennsylvania abortion regulations violated the principles established in Roe v. Wade and the right to privacy. The Pennsylvania laws required, among other provisions, spousal notification, informed consent, and a 24-hour waiting period before obtaining an abortion. The court had to determine if these regulations constituted an undue burden on a woman's ability to access abortion services. So, spousal notification, the husband, right, would have to know that his wife was going to obtain an abortion. Informed consent, there actually had to be meaningful consent on the part of the woman. She had to know what was actually going to take place within the abortion procedure. Not worth getting into now, but it's certainly worth knowing what's involved. And then a 24-hour waiting period. It couldn't just be made on a whim. So that was the law in place. Did that cause an undue burden, right? Did that get in the way too much? Was it too significant an obstacle that the state put in place to otherwise dissuade or inhibit a woman from attaining an abortion? To understand the rule in Planned Parenthood v. Casey, we must first examine the precedents by Griswold and Roe. Griswold, again, recognized a right to privacy, while Roe established a woman's constitutional right to have an abortion that really evolved or devolved from that right to privacy found in Griswold. In Casey, the court sought to reaffirm these foundational principles while introducing a new legal standard. The court declared that an abortion regulation would be deemed unconstitutional if it placed an undue burden on a woman's right to choose before fetal viability. Again, there's nothing in the Constitution that allows for a woman to terminate her pregnancy, yet the court is building upon the penumbras that were established from the Griswold v. Connecticut case and the Roe v. Wade holding. So again, there's nothing to point to in the Constitution, can't find a word. It's now precedent, right? It's built out into a tower made on the air, and we're going to look and see, what do we do with this now? The court's analysis in Casey involved a thorough examination of the principles set forth in Griswold v. Roe, as though we'll see in a second, it actually wasn't that thorough. It was largely a shortcut through existing case law to reach a decision that may have already been known before the legal inquiry began. The majority opinion acknowledged the importance of preserving the central holding of Roe v. Wade, while also recognizing the state's legitimate interest in protecting both maternal health and, again, potential life, as they said. The court sought to strike a balance between these interests and a woman's right to choose, utilizing the undue burden standard to evaluate the constitutionality of abortion regulations. So no longer looking at the trimester framework. Are we in trimester 1? Are we in trimester 2? Are we in trimester 3? We're just going to look at, does the state create an undue burden on a woman trying or attempting to obtain an abortion? That's the question to ask of this law, and is analyzed appropriately. So the court upheld the central holding of Roe v. Wade, and it departed from the Roe's trimester framework and introduced the undue burden standard as the new threshold for evaluating abortion regulations. The court held that the sum of the Pennsylvania regulations, such as spousal notification, imposed undue burden and were therefore unconstitutional. However, the court upheld other provisions, such as informed consent and a 24-hour waiting period, as not placing undue burden on a woman's right to choose. This case reaffirmed the core principles of Roe v. Wade while introducing a more flexible legal standard for evaluating abortion regulations. The undue burden test has since been applied in subsequent cases, shaping the legal landscape of abortion rights. This case marked a pivotal moment in the ongoing debates and discussions surrounding reproductive rights and the delicate balance between individual autonomy and state interest. Which brings us to the monumental decision last year, 2022, in the Dobbs v. Jackson Women's Health Organization case. So the court revisited the issue, the issue of whether the right to obtain abortion was provided by the Constitution. It was really important for the court to analyze the Constitution properly. So in other words, not just starting from Casey and saying, you know what did Casey say? What's the issue now? It's kind of the same stuff. Okay, Control C, Control V, right? It didn't want to do that. They wanted to actually analyze and say, wait a second, how did we get here? How did we get from there's a right to privacy to now there's a right to an abortion, and to the now there's whether there's an undue burden is now the new standard? No, 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 no. We're going to actually look at the Constitution and figure out why, how did we get here? And now let's analyze this issue. So the issue, or the case, or excuse me, the law at issue was the Mississippi Gestational Age Act, which basically prohibited abortion after 15 weeks, unless in the case of medical emergency or severe fetal abnormality. Sort of the standard procedure here. Here's the law. There's that's on one side of the equation, on one side of the V, and we're going to look at on the other side a woman's right to have and obtain abortion. So those two things conflict. This looks like it's an undue burden. So works his way up through the court. It ultimately looks like a slam dunk, right? We have existing case law, we have existing precedent. I believe it went through the Fifth Circuit, which, basically had no issue saying, yep, this isn't constitutional. We got Roe, we got Casey. What else do you want from us? But it was really important for the Supreme Court to be able to say, now, wait a second. When we are looking at whether we're going to abide by cases that have come before, it's going to be really, really important that we have those cases for the right reasons. So these are the kind of the four categories that the analysis walks through. I would encourage you, if you have the opportunity, to look these over. If you are interested in more, we can definitely cover this in more detail. But basically, the court's going to look at stare decisis, why we have existing precedent, and are we going to stand by the existing precedent? What it actually takes to overrule precedent. Court's not going to just do that on a whim. They don't want to be in the position of a legislature where they're just changing laws based on kind of the whims of society at that time. They're going to look at the public perception of the court. Again, if the court's constantly going back and forth that the sky is blue, no, the sky is red, no, the sky is blue, no, the sky is red, it's not a great perception of the court. And then the rational based review is going to be kind of the final piece of the puzzle. Not super important for our purposes, but I want to throw that in there nonetheless. So on the stare decisis point, the Casey court ignored the issue of the constitutionality of abortion and reaffirmed Roe solely on the basis of stare decisis. Again, to stand by things decided. That's typically a good thing. We typically want law, and we want law in place that we can stand by, that we can say, you know what, that's happened before. Here's our precedent. We're relying on it. It's now judge-made law. It's common law, and we can move forward into the future. Again, if your student's been a part of the Foundation of Law course, we get into the weeds on this. We really explore that concept of judge-made law. But for now, it's just important to recognize that Supreme Court cases, as well as any kind of judicial opinion, is based on precedent, what's come before. And that principle in law, kind of the string that ties all those together, is this Latin phrase stare decisis. Proper application of stare decisis requires an assessment of the strength of the grounds on which Roe was based. In Roe, the right to obtain an abortion was based on the right to privacy. Remember, it was a penumbra of the First Amendment, as well as what they said was in the 4th, 5th, 9th, and 14th. In Casey, the right to obtain abortion was based on the 14th Amendment Due Process Clause, which states, again, the 14th Amendment to the Constitution, states, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the law. Liberty is the main touchstone here. Again, that no state shall deny any person of life, liberty, or property without due process of law. Very important concept in the law. And this is ultimately where the concept of abortion is found within the Casey opinion. They're going to point to liberty and say a woman has a right, a liberty to obtain an abortion, even though abortion appears nowhere in the 14th Amendment. So the Dobbs court, though, is going to look at this and say, it's not in there, right? We're going to look by things decided. We're going to stand by things decided. The 14th Amendment concept of liberty has nothing to say about abortion. ordered liberty, to move on to that second point, is a concept that refers to the balance between individual freedom and the legitimate interest of society in maintaining social order. Again, that tension we've been talking about this whole time. A woman's right to obtain an abortion, her body, her choice, versus a state's interest in preserving the life of children, and particularly children that are in utero. So that tension is this concept of ordered liberty. It's a balance, right? As we as individuals enter into society, we give up certain rights to take part in society because society will actually provide other rights and protections. That's social contract theory. We discussed that in the Foundations of Law class too. But for our purposes here, ordered liberty is another aspect of law, and really in particular political or legal philosophy that the court is trying to reconcile. Ordered liberty encompasses the idea that personal liberties and rights should be respected and protected within the framework of laws and regulations that promote a functioning and orderly society. The court analyzed whether the right to obtain abortion was deeply rooted in our nation's history and tradition. That helps address the concept of ordered liberty, right? Do we need abortion to have ordered liberty? Well, let's look to our nation's history and tradition and whether it's essential to our nation's scheme of ordered liberty. So is that fundamental to our nation's well-being, to our nation's functionality? If so, then yeah, man, we should probably keep that right. If not, why are we protecting it? And via the Constitution, no less. The court found that abortion had no support in American law, any state constitutions, in any federal or state courts, with minor exceptions, or any scholarly treatise. In fact, abortion had been a crime, like we talked about earlier, for much of our nation's history. So not only is it not a fundamental right, it was actually a crime. So it'd be kind of the same thing if someone came up and all of a sudden was like, you know what, murder. I have the right to murder people, and we need it. We need this group of people to have the right to murder other people for our nation to function properly. Well, no, right? Like forever, murder has been a pretty significant crime in every society throughout any period of time. Murder was wrong. Murder was objectively wrong. It was unjust. It was evil, it was wicked. Now, bigger discussion there as to what constitutes murder, and is there ever a just time to murder someone? For our purposes here, though, it's important to recognize that in the same way, abortion was a crime. It was not allowed. It was not legally allowed, let alone legally protected as a right. So Roe either ignored or misstated our nation's history. In Casey, the Casey court simply declined to reconsider Roe's faulty historical analysis. Instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contended that the abortion right is an integral part of a broader entrenched right. Roe termed this right to privacy, and Casey described it as the freedom to make intimate and personal choices that are central to personal dignity and autonomy. However, ordered liberty sets limits and defines boundaries between competing interests. Roe and Casey each struck a particular balance between the interest of a woman who wants an abortion and the interest of what they termed potential life. But the people of the various states may evaluate those interests differently, right? How are people, not the men on the bench, not the people on the bench, but individuals in respective jurisdictions electing the representatives to make laws on their behalf, how are they going to evaluate those interests between the woman and the state, between the woman and the baby? The nation's historical understanding of ordered liberty does not prevent the people's elective representatives from deciding how abortion should be regulated, which is ultimately going to be the conclusion in the holding of the Dobbs decision. So we talked about stare decisis. Let's talk about overruling precedent real quick before we wrap up here. So stare decisis is still tremendously important. I can't emphasize it enough. It's sort of a catch-22, sort of paradox in some ways, that we're going to say it's really important until it becomes too important, and then it should be overruled. But that's why the court provided 5 factors really for any future court to think through when they're thinking about, wait a second, we went off the tracks somewhere. We seriously messed up. We have to figure out a way to get us back on course. How should we overrule precedent? The actual and perceived integrity of the judicial process, ensures that our legal system continues functioning. We don't have any sort of concept of consistency and order. The law is going to be disregarded. It doesn't matter about the enforcement side of things. People's belief in the legal system is going to undermine the legal system quicker than anything else. So stare decisis is important, but it's not an inexorable command. And it is at its weakest when interpreting the Constitution. As we'll see in the Foundations of Law course, or if you've already had students that have taken it, some of the Supreme Court's most important decisions came from overruling prior precedent. Plessy v. Ferguson comes to mind. But can the court know when it needs to overrule itself? Sort of a catch-22, right? It sort of begs the question. The court's going to do whatever the court needs to do to promulgate law, unless it's unlawful for the court to have done that, right? And prior precedent needs to actually be overruled. So here are the 5 factors that the court's going to consider and did consider when overruling Roe and Casey. 1, the nature of the court's error. It must be egregious, like the separate but equal doctrine from Plessy v. Ferguson. Again, we discussed that in the Foundations of Law class. The Brown v. Board of Education case looked at the Plessy v. Ferguson case and said, wrong. No, we got that one wrong. Got that one wrong, guys. 2, the quality of the reasoning. Roe somehow made up the trimester framework, which acts like legislation rather than law, and then went on a fact-finding mission to basically justify its conclusion. So he sort of made up something from thin air. There's kind of sort of a right to privacy, and then we're going to sort of evaluate how that right to privacy and abortion competes with the state's interest in protecting the potential life. And so rather than get through all this weak reasoning at best, it needs to be solid reasoning. It needs to be very solid reasoning. Okay, I believe we're on workability as a third factor. Workability is basically whether the rule can be understood in a consistent and predictable manner. It's really the reason why we like stare decisis in the first place. It's consistent, it's predictable. So if the precedent itself is not workable, if it doesn't make any sense, if it's just causing a whole lot of inconsistencies and unpredictable results, we're going to throw it out. Casey's undue burden test caused a lot of fragmentation across the nation's legal landscape. Underneath the Supreme Court, there's the circuit level. That's like the JV before we get to the varsity here. Mass confusion across the different circuits. You could go to the 5th Circuit, you go to the 9th Circuit, and it was just a split. It was a fragmentation, so it wasn't workable. 4, the effect on other areas of law. What other legal doctrines have been distorted as a result of this prior precedent? And then 5, reliance interest, whether areas of law have been relied upon this bad precedent. So where do we stand now, post-Roe and really post-Dobbs? States decide whether the right to obtain abortion has a legitimate state interest, usually under the guise of health care, women's health, or otherwise. And such laws need only be rationally related, which is the lowest standard when a court is evaluating such a law, to such an interest. So it's up to the states. That's where we're at right now. Certain states like Texas have passed certain laws that criminalize, again, doctors that perform abortion procedures or anybody that would otherwise aid a pregnant woman in obtaining an abortion. So it significantly curtails, as best law can, any kind of abortion. So whether it's constitutional is now not so much an issue because it's ultimately left to the states. So will there still be challenges? Yes, absolutely. Ultimately, the profound issue in abortion is left to the people and their elected representatives in each state. So there's still work to be done. I think that's a conclusion. I think it would be a poor understanding if the church thinks that the abortion problem is now solved and we can move on to other issues. No doubt there are other issues at stake, but the fact of the matter remains that babies are still murdered every single day, that some states have not only legalized, but have in fact celebrated abortion, again, under the kind of the guise of health, of women's rights. And so anytime that does come up, it's important to recognize that for what it is. It's important to recognize that the people that are celebrating such a right are really just celebrating death, and ultimately what that comes down to is that there's still work to be done within our nation. So that is the end of this lecture. We started out with Griswold v. Connecticut. We showed how the right to privacy was basically made up within reading between the lines, between those shadows that was created. The court then takes that and runs with it in Roe v. Wade and says, you know what? Yep, there's a right to privacy. See, here's this case over here. And because there's a right to privacy, now there is a fundamental right to have an abortion. And because now there's a fundamental right to have an abortion, we're going to look at the three trimesters to figure out where those competing interests between the woman's right and the state's interest align. And at some point in time, the interest no longer is sole. It's dual rather than sole, to use Justin Blackman's phraseology there. Casey looks at the same sort of issue of whether certain laws created an undue burden on a woman's right to obtain an abortion that also muddled the water with regards to the constitutionality of the right to obtain an abortion. And then the Dobbs decision came through and cleaned up the mess, basically, and said, wait a second, guys, how in the world did we get here? How did we go from, again, the Constitution to celebrating abortion on a false predication of a right to obtain abortion? So the right to privacy devolving into the right to obtain abortion. Dobbs comes out and says, you know what, states, y'all actually decide this. It's up to the people to elect their representatives to choose the respective laws. Work is still to be done. So like I said, from the jump here, I really hope that this is educational for teachers as they maybe start hearing remnants of these sort of conversations or hear misunderstandings of what the law is or how the law works. This by no means is a thorough analysis of all the legal issues or all the facts of the case. I hope that this provided a really great overview. So if you do have any questions or comments, please visit our website, riseandbuildacademy.com. You can connect with me there. You can learn about any other additional programming we may have. And if you have any requests too of other kind of laws or issues in the law that have come up within your classroom or church or community or otherwise, please reach out too. I'd love to be able to figure out how I can best serve and teach other Christian educators. So I'd be happy to connect with you. But otherwise, I pray this has been a good time, has blessed you, and I pray that you have a blessed day. Thank you very much.